Hi, my name is Maria Annerly, and today I'll be discussing an international approach to combating cybercrime. I'm going to look at this through three different conceptual elements. First of all, who the actors are and how they determine who can best and who should best act when it comes to a crime being committed, as well as where those actors can go to learn and the structures that they can use to implement actions, and then through those structures, how they ensure forward progress and efficacy, as well as preserving values and best practices. So, jurisdictional theories are ways of determining who can act in response to a crime. And so, there's things that establish responsibility. So, one country that should respond to a crime, as well as others that can and have the authority to do so. It's very complicated when it comes to cybercrime because there can be multiple locations for crimes. So, things that may all tie together, such as the location of the offender, of the victim, of pieces of technology, servers, the place of access. So these all can reside in different countries and different jurisdictions that then have to sort out who should and who can best respond. This becomes very important in determining how to investigate and gather evidence, where to extradite people to, and just facilitating those kinds of arrangements, as well as just, approaching a judicial process in general. Other factors can come into play, such as funding and who has the resources and structures to best investigate and handle things, especially of a very sensitive nature. And then the political influence, like diplomatic ties and governments may speak on behalf of their citizens when they have little to do with the actual crime that is committed. There's different ways for justice to be approached, and these theories kind of look at the responsibility to the victim, the offender, and society as a whole. And there's five main theories, but today I'll just briefly mention the theory of territoriality, which says that any country in control of the location where the crime was committed is responsible to respond. And then the theory of nationality instead looks at the offender and then puts the responsibility on the offender's country to ensure that they are following the law and to respond there appropriately. Some different forms of international discourse and action, once jurisdiction has been established, can take any number of forms. Conventions, conferences, summits are places for different people from government, academia, the law enforcement community, the private sector to come together and discuss things like cybercrime and its technical elements, its political elements, and just to grow collective knowledge. Once this collective knowledge has been gathered and expanded on, nations and political bodies may publish declarations or statements that publicly declare their belief in something, their intent to act on something, or a decision that influences actions. Then something that is more inherently action-oriented may be treaties or agreements or memorandums of understanding, which actually provide official authorization for those cooperative actions and international movements to take place. So these can be formal things between nations to agree to share resources or people, as well as more informal methods of support, different agencies in different countries. Other diplomatic solutions and political pressures may be used, such as tariffs or mediation when it comes to jurisdictional conflicts. Some best practices and values in the international progress towards combating cybercrime. These efforts have to be comprehensive. And for example, I use the Council of Europe's Convention on Cybercrime's three goals to display how these three best practices are implemented. But comprehensive means that there is an in-depth discussion of the subject and its appropriate responses. So you have to define each cybercrime, the different types of cybercrime, in order to criminalize them and their sanctions. So this is a domestic law process that can be supported in international environments. They also have to be protective of rights. So when it comes to things like domestic procedures for gathering evidence and using that evidence in court, and like just handling it in general, it has to be in ways that respect the rights to privacy and to security of the citizens. And this is something where historically has been a problem when countries don't necessarily have the capabilities to protect the information that they say they have the right to gather. So different countries are responsible to support each other in ensuring that there are appropriate safeguards in place for their citizens. And finally, it has to be representative. Cybercrime is a global issue and a global response is needed. So all countries need to have their say and be encouraged to look at this in many different ways and not just take on one nation as a lead. Some best practices, this is too much to go into in this presentation, but I'll touch on a few things briefly. We need to look at current issues and barriers to efficacy. So just because a system is in place and may work should not be a reason to leave it as is and neglect improving. Interception of data between nations, especially communications, is a big issue. The preservation of data can happen in different countries and can influence the admissibility of evidence in court. But I'll just close with a statement on there needs to be bottom-up initiatives. So in the different nations that agree to these international pacts and treaties and agreements, there needs to be individual initiatives starting with the most local level domestic agencies and local level police agencies. Otherwise, it's going to be a very ineffective top-down order instead of a bottom-up movement. These are some of the resources I used. I encourage you to go through and read some more on your own. This is a very difficult topic to cover this briefly, but thank you very much for listening.